Natasha Coley. The defendant is represented by Brown Rednick. Lead counsel is Reverend Arthur Crowd. Assisting is Roger Kennel, both of whom are appearing by way of video conferencing.
Yes, good afternoon, everyone.
Good afternoon, Your Honour.
It's good morning with you.
It is, yes, Justin. I've got no sense of how the video conference is working, or how loud it is in particular. So if I start shouting or I speak too softly, please do, of course, tell me.
Yes, so far so good.
Excellent.
Right. So, there is anything we need to deal with before we allow the applicants to proceed with their applications? Right.
We noticed that at tab 6, in error, the authority that was supposed to be there wasn't, and therefore I have the correct authority, which I may just come up to the mark.
What I'm having behind 6 is Al-Kharafi case, is that?
Yes, but that's the wrong Al-Kharafi case. So if we take that one out.
Yes, I know. There is so many decisions in Al-Kharafi
Yes,
case.
absolutely. And a copy has been sent to the applicant.
And I can confirm that I have that copy. It's the 20th of November 2014, I think, and I have a copy of that decision. And it's indeed it's indeed a decision that I rely on as well.
Well,
It is 20th of November 2014, and it is an authority that can be found in the response regarding the applicant's bundle. There is a further document to be inserted in the hearing bundle. It's an exhibit to Mr. Asif Adil's witness statement. That should be inserted as tab 18, and it's coded 239A to 239F. Again, copies have been sent to the other side.
you said tab 18. Is this a new tab need to be added?
No, it's an old tab. It's the witness statement of Asif Adil.
I didn't have 18. The maximum I have 17 in my bundle.
The hearing bundle. Updates should have been sent to you yesterday by the other side. So if I can just check with you, Your Honour, the hearing bundle index, and it should be tabbed up to tab 22.
Well, I do have the witness statement, but my hearing bundle stops with number 17.
Oh, really? Okay. So do you have the witness statement of Mr. Asif Adil?
Yes.
And which tab is that?
I don't know. I have it loose leaf.
Right, okay, so those are the updates that should have
You
been...
mean the one for the 5th of June, isn't it?
Yes, that's correct.
Yeah.
Those are the inserts that should have been inserted into your bundle. Your Honour, I don't know if it's worth our while just to take a couple of minutes to check your bundle and see that everything is in order there.
There was, Your Honour, an update to the hearing bundle, which runs from tab 18 down to tab 22.
I didn't seem to have been copied with all of that.
Your Honour, if we just check what you actually got, you should have been sent a new index.
A new index.
A new index that should have included tabs 18 to 22, following on from tab 17, and then documents relating to tabs 18 to 22.
Yes. Yeah, I'm told usually the preparation of the bundle is the party's work. It's not the court work usually.
We understand that.
And yes, my clerk just said it might be sent by email, but it's not. My file was not updated.
It's...
By the other side yesterday, I believe.
That's right, and I had understood that a hard copy had been filed at court, and if that hasn't happened,
Then it must
which
be
it sounds like it may not have happened,
The registry, the Ramadan working hour is much shorter than the previous days.
that may be the reason. In any event, Your Honour, in any event, we might be able to short-circuit matters like this. Your Honour has the copy of Mr. Adil's witness statements and the exhibits attached thereto. The only additional documents in the bundle, which Your Honour doesn't have, are the skeleton arguments for the parties. And I hope that Your Honour has those two documents in any event. And if that's right, then it doesn't matter, so far as I'm concerned, that you haven't got a bundle that runs the 22 tabs, because you have all of the documents that are contained within the bundle.
I do have the skeleton argument for both parties, but in separate...
Yes, well, it's not quite what... It's not quite what Mr. Tukrad is saying. There's the witness statement of Mr. Asif Adil, prepared in response to the application. There are exhibits attached to Mr. Asif Adil's witness statement. And Your Honour, there are also draft orders prepared by us, and of course the skeleton arguments then appear at the end. But I do have copies for you, which I can recommend that you can insert into the back of the bundle.
Yeah, I think the best way to do this, I guess, you give me whatever you have, and I'll be very flexible to accommodate whatever submitted by parties during the last 2 days. And just take me through, if any of the important you're going to put before me now important, you just take me through during the discussion.
Indeed. So Your Honour, I'm just trying to look for the record inside the index sent yesterday. Extra copies that should be inserted behind tab 17.
Right. Right, I have an updated file now.
Great, so that should be completed, a copy of the bundle, and there are some housekeeping matters.
Unless you have another housekeeping matter, Mr. Rounder, you may start with the case. You need to
No, I'm very grateful. Sorry.
You need to take me through why you don't want to pay the money.
I'll endeavour to do that, Your Honour. I'm grateful to my learned friend also for handing up those additional copies. I'm not sure what's happened, but we are where we are. So, this is the appellant's application. That appellant's application is dated the 1st of May 2016 for a stay of execution of certain paragraphs of the order of Justice Roger Giles. That order was made on the 29th of May 2016 following a trial and judgment. And pending the determination of the appeal, and Your Honour will have noticed, I'm sure, from having looked at the documents and the skeleton arguments, that permission to appeal has been granted by the Chief Justice. I'm glad now that you have all the documents that you will need before you, and so I'd like to take you through some of those, if I can. If I could take you first to the order of Justice Giles, which is at tab 10 of the hearing bundle. Apologies, it's not tab 15 of the hearing bundle. Yep. You all will see at paragraph 3 the order. Oh, sorry, apologise. Does you want to have it? Yeah. You all will see at paragraph 3 there the orders for payment that the judge made on the 29th of May. Paragraph 3A is a sum in excess of £1 million dirhams, representing the equivalent of 6 months' salary in lieu of notice. Paragraph B is the sum representing the end of service gratuity of 218,000 dirhams. Paragraph C is the statutory penalty of some 6 million dirhams. The rate there, the conversion into dollars is $1.6 million. Paragraph D, prejudgment interest on the amounts, on those 3 amounts, amounting to 225,000 dirhams. And then over the page, paragraph 4, post-judgment interest on those amounts at paragraph 3, from the date of judgment until payment at a rate. And paragraph 5, and this is important, statutory penalty payable pursuant to Article 18 shall continue to accrue at the daily rate or the dirham equivalent of US $1,643 from the date of judgment until payment in full of both of the amounts in paragraphs 3A and 3B, 3A being the equivalent of 6 months' salary in lieu of notice, 3B being the sum representing the end of service gratuity, and post-judgment interest shall accrue on the penalty at the rate set out in paragraph 4. Paragraphs 6, 7 and 8 are irrelevant for the purposes of this application. If I can take you then to the application itself at tab number 1 of the bundle. You'll see on that the application was dated the 1st of May 2016, so well in advance of the final order in the case having been handed down. And if you could turn over to tab 2, you'll see that in our draft order, what we said was, what we asked for was that the statutory penalty amount ordered to be paid by the appellant and set out in paragraph 5C of the judgment, so we didn't have an order at that stage, dated the 30th of March, be stayed pending the determination of the appellant's appeal. That application was made at the same time as the appellant's application for permission to appeal was made, so the grounds and skeleton was submitted at the same time. 2 brief points then, turning back to the order if we can at tab 15 of the bundle. The appellant applies for a stay of paragraphs 3C of the order, so that's the statutory penalty amount of $1.6 million.
Right.
3D of the order, that's pre-judgment interest on the other amounts, including the statutory penalty amount. Paragraph 4, which is post-judgment interest on all of the amounts, including the statutory and penalty amount. And paragraph 5, which relates to the statutory penalty. So the focus of our attention, Your Honour, is firmly directed at the statutory penalty and nothing else. Your Honour may well have seen in the arguments about the payments that have been made already, received and recognised by the respondent to this appeal, and this application has nothing to do with those payments. The order was made, the payment was made satisfying that order, and that's not of, well, for the purposes of this application, its only relevance is to demonstrate that we have paid it. But in respect to the statutory penalty, the position is different. If I could, so that's our submission. So if I could take you to some of the other relevant documents in the bundle very briefly. Tab 3 of the bundle Tab 3 of the bundle is Mr. Sakara's witness statement in support of the application. If I could take you to tab 4, the exhibits to that witness statement, and at page 39 of the bundle, I want to familiarise Your Honour with a decision of the Maputo Court, which is relevant and which I shall be taking you to briefly. So then, what's the current? Sorry, let me just make one brief point about what the respondent says in its response, and in particular the scope of the application that's before you, Honour. There is no cross-application has been made by the respondent. So the respondent's draft order is the application for a stay should be dismissed and costs should follow. Paragraph 71 of the skeleton argument. Paragraph 71 of the skeleton argument. Can I just take you to that for a minute, please?
Yes. So what's the paragraph number? You take me to
71.
Respondent skeleton
The
argument?
respondent skeleton argument, I'm not sure what tab that is in your bundle, but I think it might have been loose. It's a respondent skeleton argument at paragraph 71.
Oh, no, it's only 68 paragraphs. No 71. The last paragraph.
Okay, well, I'm not sure. I'm not sure why that's the case. It may be that the counsel for the respondents may be able to have it. In any event, I can deal with that in the course of the hearing.
Or maybe you mean 17 maybe.
No, I mean, I've got 71 in front of me. In any event, the respondents' counsel, I hope, will be able to help me on the position as regards that, and we can deal with that as and when it arises in the hearing.
Well, I'm very
So
sorry
then,
for the-
no. It's certainly, it's not a problem for the time being.
Go ahead, please.
Yes. So the current state of the proceedings is that following judgment, the respondent has been paid a large amount of the sums due to him. All of the amounts other than the statutory penalty and the interest related to that sum. Permission has been granted by the Chief Justice, and yesterday the registry asked the parties for their availability for a hearing of the appeal either at the next appeal sitting, which is either the week commencing the 4th or the 18th of September. Subject to the parties' availability, and so far we've heard nothing to suggest that the parties aren't available. That's when the appeal will be heard, 3 months or thereabouts from today's hearing. So if the stay were granted today, all things being equal, the period of time that the stay would be required would be 3 months plus the time it takes for the Court of Appeal to hand down judgment. You want to have seen in the skeleton argument that I submitted that I do rely to some degree on the terms on which permission's been granted. Let me be clear. I'm not going to say, I make the mistake of saying that, well, the Chief Justice has granted permission, he thinks that there are merits in it, he thinks the points is of public importance, so my work is done, the application must be granted, we have a stay. I'm not going to say that. I'm not going to say similarly that because the Article 18 point is of real significance to the IFC employers and employees. A number of judgments are outstanding which are where this Article 18 point is relevant. One of your honours cases.
I do have one.
Eric Lees, yes. That case is waiting for an Article 18 determination. I don't think judgment's been handed down as yet. Similarly, Peter Gray's case against Gibson Dunn. Article 18 is raised there in respect of monies Peter Gray says he's entitled to. And the position as regards cases, employment cases in the Small Claims Tribunal too, those cases that we aren't fully aware about, but nonetheless, one can imagine that there are a number which involve the issue of Article 18, and it is of some importance, and in my submission that's why the Chief Justice gave reasons as he did, and certified that it was a point of public importance. What's the relevance of that? Well, the relevance of that is that in my submission, the Court of Appeal will be anxious to hand down judgment sooner rather than later, so that there is some clear guidance as to what the right interpretation of Article 18 is, whether Justice Giles' interpretation of Article 18 was right or not. And that does affect the exercise of discretion in this case, in my submission, your exercise of discretion in this case, your honour's exercise, because it may well affect the amount of time that the stay, if granted, it has to apply. This isn't a stay that's being asked for years and years. This is a stay that's been asked for until the determination of the appeal hearing. That said, as I said at the start, I'm not going to make the mistake of saying, well, I've got the permission, I've paid some of the money, that's the end of it, I win. That's not my submission at all. I know from the authorities, and from the authorities of this court, and from the authorities of the English court, and from practice, that I have to establish grounds for a stay. I have to show that the appellant will be prejudiced by the refusal to grant a stay if the appeal subsequently succeeds, and that prejudice is greater or more significant than the prejudice that the respondent will suffer if the stay is granted and the appeal fails. Now, in respect of the evidence and the grounds in support of the stay, I say that evidence is contained in the judgment itself. It's contained in the evidence that the appellant has put forward, and indeed the respondent has put forward. That evidence in my submission suggests that the appeal will be stifled, and importantly, on the other hand, and a lot of my submissions will be focused at the reply evidence of Mr. Adil. In my submission, the alleged prejudice that the respondent says it will suffer as a result of a grant of a stay is a fiction. The submissions that have been put in don't bear the slightest scrutiny. They, in my submission, are supposition and speculation and no more. And when one considers the fact that the hearing will take place, the appeal hearing will take place in 3 months, and that, importantly, the respondent on its own case hasn't got the evidence, the information, importantly, to start enforcing the order, so the procedural position of the enforcement proceedings, that being that the respondent hasn't got the information it needs to start enforcement proceedings, is important too. When one bears in mind that procedural context, in my submission, the just order between the parties is to grant a stay. One may ask the question, what can the respondent achieve now that it can't achieve in 3 months plus the time it takes for the Court of Appeal to hand down judgment? In my submission, the respondent's position is exactly the same. All it can say is that it will be out of money ordered to be paid for that period of time. And it's important to bear in mind too, when we think about this money that is ordered to be paid, this is not compensation. This is not money that is paid out, that has been that the employer's wrongly withheld. That money that the employer has found to be wrongly withheld has been paid back. This is a penalty. This is not damages, where he's been kept out of money. The suggestion in the skeleton argument being kept out of his money, kept out of the penalty. It doesn't mean kept out of the penalty at all. But the penalty operates by operation of law. It isn't a damages claim.
So is this an important point for you or a secondary point? Because I just see you jumping into for me, which is a slightly secondary point, because you need to convince me why it's important for you not to pay, instead of why the respondent cannot wait for their money, you know what I mean? So the burden for you to prove why it's so important to you not to pay now. And instead of the money is not important for them now. It's their money.
Certainly, I will go through those reasons why I say that the appeal would be stifled. That's the test in the event that no stay is granted. But it's important, and the authorities that I will take the honour to make this clear, that it is a balancing exercise. It's balancing the prejudice between that the parties would suffer given certain factual scenarios. And in my submission, in order to balance the prejudice, the court, in my submission, must investigate what prejudice the respondent says it will suffer as a result, and balance that against the prejudice, I say, the appellant will suffer in the event that a stay is refused. And when one balances that prejudice, in my submission, it's clear that the balance comes out in favour of the appellant. Notwithstanding the fact that the respondent is out of his money, and I bear that fully in mind. This is The effect of a stay is to prevent the respondent from receiving money that it is entitled to. I fully accept that. And the authorities emphasise the importance of minimising the risk, and we'll see in the Karafi case. Justice Giles talks about minimising the risk of loss to the respondent party, to the successful party in the litigation. But the procedural context of this application, the procedural context of the case at the moment, in my submission, is helpful to my application, because I say that the respondent, frankly, won't be in a better position now. Sorry, the respondent won't be in a better position in 3 months plus the time it takes for the Court of Appeal to hand down judgment than it is now.
Well, let me ask you this. It's a bit important for me. I mean, the question is, before I allow you to go on with this. Tell me, what is it important, like, to know that? Is it your case that you can't pay or you don't want to pay now because of the risk? I think it's, if you can't pay at all, that's something else. If you can pay, but if you don't want to pay because there is risk exists, and then that's why you want to apply for stay, so the discussion would take another direction, in my belief. So you can answer this question first, and then we can continue.
Happily, I will certainly make that answer that question. The position of the company at the moment is it's in very poor financial health. It's a small company. It has 2 directors and 6 employees. The judge, in his judgment, and if I can take you to this, it might be helpful, tab 10 of the appeal bundle. Paragraph 68 of the judgment. The judge recalls and finds that as at the 30th of June 2000... Sorry, Jon, I apologise. Do you have that paragraph?
68, yes.
Yeah. Frontline was not yet profitable. As at the 30th of June 2013, it was in the red to the tune of approximately $3 million.
Right.
There has been no significant improvement at all since June 30th, 2013. And the respondent is fully aware and indeed relies on the fact that it has concerns about the ability of the appellant to satisfy the judgment in its own evidence. So if I could take you to Mr. Adil's witness statement, please. I'm not sure what tab that is, or whether that is a tab in your bundle, but in our bundle it's tab 18. Page 220. Yeah.
Oh, the new, yeah. Yes.
I can take to paragraph 14 of that statement. So this is the evidence of someone who has detailed, intimate knowledge of the workings of the company, having been employed there for some time. He says in paragraph 14, in August 2015, I was extremely concerned that in the event I was successful in the proceedings, FDPL would be unable to satisfy any order for payment. There's a second sentence here also. I was also aware that FDPL was disposing of its assets. Those are the 2 sentences that I would ask you to look at. In respect of dissipation, I would deal with that later. But so the respondent's own evidence that it hasn't got, so far as it's concerned, it hasn't got the money. That's why it's asking for information as to the appellant's assets, saying where are these assets? Can you satisfy the judgment? I have, and not just I'm neutral about the position. Maybe you have the assets, maybe you don't. as at August 2015, so 2 years after June 2013, he is extremely concerned that the company isn't able to satisfy the judgment. So when one considers, so to answer the question, when one considers the question the court needs to answer in deciding on a stay, will the appeal be stifled? What is the prejudice that the appellant will suffer in circumstances where a stay is not granted? In my submission, the evidence is there. It's the respondent's own evidence in part, the judge's own evidence in other part, that this company is in poor financial health and will have difficulty. And it's worth remembering also that this is a sum of some $1.6 million. This is a substantial sum of money for which and a small company being required to pay in order to pay that amount of money is very difficult indeed. Now, in terms of won't pay, well, one reason why, in dealing with that part of your question, one reason why it might be suggested that the respondent won't pay is because it's dissipating assets. And indeed, paragraph 14, and the sentence that I've shown you there, is that Mr. Adil's belief is that he was aware that Frontline was disposing of assets. That's a very positive statement. It's important. It's worth noting, in the skeleton argument, it's watered down a bit. My learned friend says, well, there may be evidence that Frontline is deliberately dissipating assets. But Mr. Adil's statement is very clear that he was aware that there was dissipation. Now, if that were truly the case, the first thing one would think about doing is applying for a freezing order to stop that dissipation from happening. This isn't a case where you suspect. This is a case where Mr. Adil knows, he says.
Well, you don't go for it. Well, you have a judgment in your favor, isn't it? You just go force it.
Oh, yeah, absolutely. Certainly, it's well able. It's mainly before a judgment is handed down, but it's certainly possible to obtain a post-judgment freezing order to prevent the dissipation of assets, in order to stop a judgment debtor from dissipating assets to avoid payment of the judgment sum. And yet no application's been made. And why? Because frankly, the evidence isn't there. There is no evidence of dissipation. Had there been evidence of dissipation, positive evidence of dissipation, an application for a freezing order would have been made. And if you could turn to paragraph 15, I'm not sure if you've got the witness statement still open there. Paragraph 15.3, Mr. Adil is very clear that the possibility of a freezing order is open to him, but he hasn't proceeded. So this is one of my points in respect to the prejudice that the respondent says it will suffer. It says, oh, there's dissipation. If there's a stay now, I'm going to suffer because Frontline is going to dissipate all its money. Well, the evidence doesn't support that at all in my submission. Going back to the difficulties that the appellant suffers, so the prejudice the appellant will suffer in circumstances where there is no stay granted, it's important to understand, as I say, in my submission, the position that the respondent finds itself just at the minute. So, as you will be aware from the most recent correspondence of the Respondents' Council on the 1st of June 2016, the respondent continues to seek information about the nature of the assets. So far as the respondent is concerned, the position as at August 2015, when he originally started requesting information about the defendant's, the appellant's assets, and now it is no different. It needs information, it says. Can I take you to that letter? It's tab 16 of the bundle, and that's a letter of the 1st of June 2016. 6 of that letter sets out the sorts of information that it says it needs. So it says, in light of your client's recent appeal and stay application, given the statutory penalty plus interest portion or judgment orders represent the largest portion of the judgment sum, our client makes a further request. Please provide the following information. 6.1. Itemised list of assets in the UAE, showing asset value. So that's important. 6.2. Itemised list of debts, the amount of the debt. 6.3. Copy of audited balance sheet. 6.4. Identity of person and entity funding the proceedings and the appeal. So, at the moment, the respondent says that it hasn't got any information at all, really, about the financial position of the appellant. And at 6.1 asks for a value of each of the assets that the appellant has. Now, what does that mean in practical terms? In practical terms, if no stay is granted today and the respondent continues on with this request, makes an application, there is a separate issue here, because I say that the court has no jurisdiction to make an order or a request for further information under Part 19 of the RDC in respect of a judgment debtor's assets. That's not the Part 19 is all about issues between the parties at trial, liability and quantum. That's what Part 19 requests are directed at, not whether or not you can satisfy a judgment sum. And there's authority to that effect. You may have seen that in my skeleton argument. In any event, that's a side issue. The main point that I'm making is that if no stay is granted today, and assuming in the respondent's favour that an order for this information is made, what happens? The appellant has to then go about finding this information, conduct valuations on its assets, incur fees in respect of those valuations, expend management time on providing that information. And all the time, the clock is ticking on the appeal. So all the time, September draws closer and closer. This respondent is not in a position to make interim applications for third-party debt order or a charging order because if presumably one would have been made, or certainly an intention would have been evinced in the papers that one is imminent. That's not the position of the respondent. So when one considers again this idea of stifling the appeal, distracting the appellant's limited resources away from the appeal to complying with an order to provide information in circumstances where no stay is granted, in my submission, that supports the appellant's case that a stay should be granted, because it's very difficult to see what the moment the respondent will gain, given the position that it's at, and on the other side of the coin, it's very easy to see how difficult the position of the appellant would be if he is required to comply. Let's say then no stay is granted, and somehow the respondent manages to obtain, to enforce the order for payment of 1.6 million and interest against the assets of the appellant. Somehow it manages to do it. What is the effect then on the appellant in terms of its prosecution of the appeal, in terms of the prejudice itself? Well, in my submission, it's substantial. You have seen, Your Honour, the financial position of the evidence on the financial position of the appellant, and if the respondent manages to enforce a judgment for 1.6 million plus, $1.6 million plus against an appellant in those circumstances, the consequences are devastating and will affect, importantly, its ability to continue on with this appeal. An appeal that is important. It's not even that the appeal is important. It's important that the appellant is in the position to prosecute the appeal properly. It's worth recalling that in this case, Justice Giles had a separate hearing in respect of the Article 18 point. There was a trial in May, and then further following that, there was a separate hearing. And in respect of that hearing, the parties provided substantial, lengthy submissions and authorities following the direction of the judge that he wanted as much assistance as possible as to the proper interpretation of Article 18. That is the sort of preparation that will be required, if not more, frankly, given that now we've got a judgment explaining what Justice Giles says Article 18 means, that the appellant will have to do between now and September. And that is a costly exercise. And in my position, the appellant's resources are better spent on ensuring that the Court of Appeal is assisted as much as possible for the purposes of that appeal, than it is dealing with that's a better way to spend the appellant's money than it is for the appellant to spend its money on professional valuations of its assets, of dealing with the request for information that the respondent may obtain an order in respect of, especially in circumstances where, as I say, it doesn't look as if the respondent is close at all to making an application. Again, it's the respondent's own case. Frankly, some of it's very helpful to me. If I could take you to Mr. Adil's witness statement again. And this is the paragraph 31 of the witness statement. This is the position as regards beneficial ownership of the company, and importantly, for want of a better phrase, Indian connection. Paragraph 34, Mr. Adil says, shareholders and Mr. Chatterjee, the group chairman, are not resident in the UAE. No connection with the UAE, no assets in the UAE, making enforcement of any award virtually impossible. And then 35, 36, 37 goes on to talk about the operation of the appellant in India. So far as the respondent is concerned, it may need to go to India.
Mic away from the paper, please.
I'm very sorry. I'm very sorry, Your Honour. Very sorry. So far as the respondent is concerned, then, it may need to go to India to enforce this judgment. And in the event that the appeal fails, well, of course, it's entitled to go to India. It's entitled to go to India now. But the position at the moment is that it doesn't seem to make any inquiries about the location or accessibility of any assets in India. All work that it has to do, all work that the appellant consequently has to do in responding to requests in respect of those assets, and work and money and resources in my submission that are better spent dealing with an imminent appeal. Some of the other difficulties that the respondent says it will face in the event that a stay is granted and the appeal fails are set out in Mr. Adil's witness statement and set out in the skeleton argument. I'd like to deal with some of those. I've dealt with the idea that the allegation, that the appellant has dissipated assets, and in my submission there's no evidence of that whatever. It is an extraordinary allegation and completely undermined by the absence of any application for a freezing order. Mr. Adil also refers to the alleged investment in a property development in Dubai. Let me get his witness statement a second. Yes, paragraph 28. Does you want to have that? Yeah, page 225. Yeah. Paragraph 28. Disclosure order made by Your Honour, indicating a payment to Maidan. What's happened?
Excuse me, this needs to be corrected because I think the judge is issuing this as Judge Omar al-Muhairi, not Ali. So it's, there is,
oh yes, goodness, sorry. That's right. That's right. Yeah. Sorry, I apologise, Your Honour. I got confused by that too.
It's not your fault.
It's the appellant, as Your Honour will know, because Your Honour refused the appellant permission to put any further reply evidence in response to this witness statement, so I can tell you, but I can't produce a witness statement confirming this. I can tell you that the appellant has never invested in this development. So the concerns about assets in Dubai in respect to this development aren't borne out, and the reliance in respect to this development doesn't work. Another point that they make is in respect of the trade licence. So, if I can turn to the respondent's skeleton argument at paragraph 62 and 63.
Whose skeleton argument you're referring to?
The respondent's skeleton argument, Your Honour. It's page 267.
Sorry, what paragraph?
Paragraph 62 and 63. I think it begins the DIFC Register of Companies. Do you have that?
No, 62 said the court has the ability to grant a stay. 63 submit that.
Paragraph 60.
60 reads for the reasons set out in the respondent witness statement. Yes.
Then I think, yeah, it seems that there is some confusion here because the skeleton argument that I have for the respondent, dated the 5th of June 2016, has 71 paragraphs. That was what was served on me. It seems, Your Honour, that you have a different document.
I guess so. We've been given different information.
Can counsel for the respondent explain perhaps what has happened?
Yes.
I can tell you, I've spoken to Natasha Collins, who served the skeleton argument. The skeleton argument that we served on the applicants was served at 8:40 p.m. and that skeleton argument has 68 paragraphs, and we have the email here showing the attachment. The skeleton argument that was served or on file with the registry again was emailed at 8:31 p.m. and again at 8:57, and that also has 68 paragraphs. And so we're at a loss to understand why it is that the applicants have a skeleton argument consisting of 71 paragraphs.
With respect to my learned friend, it must have only come from her or her firm. I couldn't have got it from somewhere else. I'm not quite sure what's happened, but there has been some confusion.
That's the point that the applicant is making, but we have gone through our emails and the skeleton argument is at 68 paragraphs, so we can do another search of the emails and see if anything else was served in the
I'm not sure. I'm not sure if it matters now. But in any event, you're on somewhere in the skeleton. Yeah, stop.
So was it served in a Word format or a PDF format?
PDF.
So that's really that.
Well, I think we are where we are. Hopefully, Miss Arman may be able to help, but hopefully you've got paragraphs relating to the company registrar point and the trade licence point. Is that paragraph, did Miss Arman say 59 of your skeleton argument?
If it assists, we can resend the email serving the 68 paragraph skeleton argument both on the registry and on the system again.
Can you send it now?
Yes.
Yeah, if you can send it out, I've got an iPad and I can pull up the right paragraph references on that if that's all right, Ron.
It's coming shortly.
Thank you.
Ms. Ahmed, do you have access to the internet?
Yes.
Right.
Yeah, I think we found the version of it.
Yeah.
So it's the one served at does the appellant have
Yeah, we did.
Yes, A41. I've got it now. All right. So.
Oh,
Yes, so-
can I send the issue?
Exactly where you are, Your Honour, yes. So again, here's the point the respondent makes. Respondent says, if a stay is granted, I'm going to be prejudiced. And part of that prejudice is the fact that the trade licence is due to expire the 27th of June 2016. And it says, paragraph 59, meaning it is possible FDPL will cease trading on expiry of its licence. Furthermore, enforcement against FDPL via the DIFC and or Dubai courts will be difficult once its trade licence is no longer valid, no longer trading, no longer an active registered company. And again, 60 really repeats the same point, making any 60.1, making any recovery of the penalty extremely difficult. And then 60.2 is the India point we dealt with a minute ago. The position on the licence is this. My instructions are, and again, you want to please bear with me, that I haven't been able to put this into a witness statement. My instructions are that the appellant will renew its trade licence in the DIFC, and so there is no possible prejudice that the respondent will suffer as a result of the expiry of the trade licence on the 27th of June 2016. I am told by my client an application for renewal of the trade licence is made around a week before the expiry of the existing licence. That's what it expects to do, and that's what it will go on to do. So,
I might agree with you. That's the logic, I guess. No one would renew the license months ago, a month way before the expiry of the trading license or whatever.
So the prejudice that the respondent says it will suffer, in my submission, isn't there. The next point that the respondent makes, prejudice that it may suffer if a stay is put over.
This your statement is supported by any evidence? I heard you said your client instructed you.
You're on the position. The position is that you may recall on Sunday we received this reply to the application on Sunday just gone. Prior to that, we had asked the court for permission to put in any reply evidence to the response that we were to receive on Monday. We asked the court to grant us permission to put that reply evidence in by Monday evening. And
you mean
we were... No, certainly not. No, yesterday night.
I see.
And so we asked the court for permission to put in reply evidence to deal with any points that may arise in the evidence we were to receive on Sunday. The court denied that request and so we have not been in a position, we weren't given permission to put in any reply evidence to deal with the points in this reply. That's why all I can say is that those are my instructions. But if I had the opportunity to put it in a witness statement, I would have done.
Yeah, you're right, I guess. But as I said, this at the beginning of this hearing, I'll be more flexible with the parties for the nature of the application to submit some other documents and evidence, maybe. What I see fit.
I'm grateful for that indication, Your Honour. It's the circumstances that, you know, of the hearing being in very short order that we weren't able to put in reply evidence in the circumstances. But that's the position as regards the trade licence. So I say that the respondent's concerns in respect to the trade licence aren't borne out. Now, the respondent's concerns also about the financial position of the appellant are also referred to in Mr. Adil's witness statement. If I could take you to that, please. Paragraph 24 and 27. So, paragraph, do you have paragraph 24, Your Honour? Paragraph 24, thank you. Paragraph 24, Mr. Adil says this. In March and April 2016, my solicitors conducted asset searches to ascertain FDPL's financial ability to pay in the event of a favourable judgment to me, and or identify assets which a judgment could not be enforced against. I was told by my solicitors that no assets were identified for either FDPL or Mr. Chaturvedi. The same point is repeated at paragraph 27, the second full sentence at the bottom of the page. I'm also concerned that the asset searches conducted by my solicitors in March and April 2016 did not identify any assets. The confusing thing for me, when I read this sentence, was that the underlying documents, so confirmation that the asset searches that have been conducted prove or established that so far as the asset searcher was concerned, is not in evidence. None of it's in evidence. So this is assertion on the part of, and hearsay on the part of Mr. Adil, that someone went out to find assets and couldn't find anything. In my position, that can't be evidence on which the court can rely.
Why are you complaining about this anyway? Because you said you didn't have assets. You said you didn't have enough cash to pay. I mean, why are you complaining?
Because I'm sorry, Your Honour, sorry.
Yeah, that's what I'm saying. You yourself complaining about your company, your client inefficient cash or assets to pay the debts from now, or at least financial difficulties. So
no, that's
what they're saying, I think, goes in the same loop, I guess.
No, indeed it does. Indeed it does. But to the extent that it's suggested that all the evidence of the absence of any assets is harmful, and a stay shouldn't be granted because the assets aren't there, and we need to get on and find those assets, in my position, it doesn't help them at all. It doesn't help them at all, because the evidence of the evidence, underlying evidence, just isn't put before you. And so, sorry, Your Honour, sorry.
You may continue.
Thank you. The respondent then makes a point, well, it hasn't responded to our requests for information on the identity of assets. We've asked, the respondent says we've asked on numerous occasions for information in respect of this. We've made a request, as Your Honour has seen, on the 1st of June 2006. and still no information about the location of assets. This is evidence of an intention not to pay. This is prejudice that we will suffer in circumstances where a stay is granted today. That's the respondent's case. Now, and I briefly mentioned to you, Your Honour, it's my submission that Part 19 has no application in enforcement.
You're saying the evidence of Mr. Asif is not supported by any other evidence. Is that what you're saying?
I'm saying that they can't simply assert, Mr. Asif cannot simply assert in his witness statement things that have where there are underlying documents which are said to substantiate that assertion but that haven't been put in evidence before you. You cannot, in my submission, attach any weight to the evidence of Mr. Asif in respect of the difficulties that he says he will face in circumstances where a stay is granted. If the underlying documents are known. The underlying documents in my submission must be there for the court to be satisfied, because this is all part, in my submission, of the balancing exercise that the court has to undertake when it decides on the balance of prejudice in exercising its discretion. That's what this application is all about. So that's very difficult, it seems to me, for the respondent. Let me deal then, as I say, with this failure to respond to information. So, the respondent's point is we've asked them lots of times for information about the location of assets. We haven't got it. If I can take you to a single authority now. I hope, Your Honour, and it may be hopeful, but still, you have 6 authorities that the appellant has put in with its skeleton argument. Do you have those authorities before you? Do you know?
Attached to the skeleton argument, to the appearance skeleton argument bundle?
That's right, yes.
Yes, I do have 6 of them.
Excellent, excellent. I am relieved. The first case, hopefully, is a case called XYZ and Various. Do you have that?
Right.
So this is a case from 2013. And this case is about faulty breast implants and a claim on behalf of nearly 1,000 women who sought damages from companies running private hospitals in respect of those implants. If you look at paragraph 5 of that judgment at the bottom of the first full page,
Right.
Paragraph 5 says, by this application, the claimant seek an order that transform, that's the defendants, to provide information to the claimant as to the nature and extent of its liability insurance cover in respect of its potential liability in its proceedings to the relevant claimants on the group register, or that it do serve a copy of the relevant insurance policy documents on those claimants. So what the claimants want is evident that they're concerned about the financial stability of the defendant, and they want information about the insurance arrangements of that defendant. Now, paragraph 6 of the judgment, in the course of his submission, so that's counsel for the claimant women, he wants to know whether Transform has sufficient insurance. Why? 1, to fund its participation in the litigation to the end of the trial. 2, to meet any order for damages. 3, to meet any order for costs. The court then goes on to discuss the paragraph 15 of the judgment, so over the page. Mr. Waite, paragraph 15 says, Mr. Waite, who is counsel for the defendant, says, the court has no jurisdiction to make the order, either as sought in the written application or as refined. The claimants rely on the CPR, Rule 3, and Part 18. Part 18, of course, in the CPR is our Part 19 in the RDC. Rule 18.1, the court may at any time order a party to A. Clarifying the matter, you will be very familiar with these provisions.
Right.
So the court then goes on to discuss whether it has jurisdiction to make an order under what is CPR Part 18, what would be our Part 19, as to the insurance position of the defendants. Paragraph 22, paragraph 20, 21 and 22 over the page reference to a case, West London Pipeline and Storage. It's a judgment of, as he then was, Mr. Justice David Steele, in relation to the Buncefield explosion and insurance claims arising out of it. Paragraph 22 is the operative paragraph, and the quote of Mr. Justice Steele: "The court has no jurisdiction to require disclosure of the insurance position, not disclosable under Part 31, so the ordinary standard disclosure rules. They do not support or adversely affect any party's case, not relevant to the issues, nor do they constitute documents which may lead to a trail inquiry, enabling a party to advance his own case or damage his opponents." Then over the page, paragraph 29. Paragraph 29, I accept Mr. Waite's, that's counsel for the defendants, I accept Mr. Waite's submissions that the claimant's request does not come within Part 18. The insurance position of the defendant is not a matter in dispute in the proceedings. Information matter doesn't relate to the matter in dispute. So at the moment, as you've seen from the letter of the 1st of June 2016, the respondent's letter, it relies on our RDC Part 19 for information as to the location, identity, value, etc. of the assets. And it can't use that. It can't use Part 19. So, well, you may say, well, what does it matter? The court hasn't got jurisdiction, if I'm right, if the appellant's right, the court's got no jurisdiction to make an order under those terms. It matters from the point of view, in my submission, purely and simply of timing. If the respondent, as it seeks to, in its letter of 1st of June, continues on this course of making an application under Part 19, in my submission it will fail. It will then be stuck, because it still has no information as to the location, identity, value, etc. of the appellant's assets. The clock keeps ticking. The appeal hearing comes closer and closer, and the value of the absence of a stay, so the value of the respondent of being able to enforce a my submission is diminishing all the time. That, in my submission, is relevant to the question of whether or not you want to grant a stay today, because, in my submission, the respondent's position in these enforcement proceedings is mistaken. He has other ways under the RDC, as your Honour will be aware, to obtain information about a judgment debtor's assets, and it has chosen the wrong course. If it continues to do so, nothing will happen. And so, the point that we make, put simply, is that the respondent's position, the respondent will be in no better position in 3 months' time if a stay is not granted, where on the other hand, the appellant will suffer enormous prejudice, as you all have seen, or will have seen, and has seen, if a stay is not granted. So the effect of a stay, given the approach the respondent has taken, in my submission, assists my application. If I could turn back to that letter the 1st of July, again, apologies, June. Yeah, this is tab 16. It's a small point, but it's an important point. Paragraph 4.4, so page 217 of the file.
Right.
Again, something that the respondent relies on to show that the appellant isn't interested in complying with court orders. FDPL agreed on the 10th of May 2016 that the claimant's indemnity cost in the sum of $2,500 with respect to FDPL application for permission to appeal accepted, but the amount's not been paid. Is their point? The amount's not been paid. Well, since the 1st of June 2016, that amount has been paid. It is not now asserted in the skeleton argument, the subsequent skeleton argument, that this alleged default on the part of the appellant supports the respondent's case. So, you know, as you want to put it, can't pay, won't pay. This isn't a respondent that won't pay. It had a cost sort of $2,500, which was made by the registrar because the appellant asked for more time following its change of counsel to put in its application for permission to appeal, its grounds and skeleton argument. It got that extension of time, but at the cost of $2,500, which the registrar ordered to be paid. It has now paid that money.
So you saying this
4 points.
was in your favour, isn't it?
It was in our favour, yes. We asked for an extension of time to put in grounds of appeal and skeleton argument in support of the appeal. There was a change of counsel following judgment. We came on the record and needed to get familiar with the papers. The registrar said, you can have that extension of time, but you will pay the other side's costs. And we did so. As at the 1st of June, we hadn't. Following that, we have. Now, 4.3, this is something just above 4.4 in that same letter. Respondent says, well, again, more evidence that, respondent won't pay. He hasn't paid our costs, the appeal costs in respect to the security for costs application, despite a number of communications in that regard. Now, you all have to bear with me a bit because obviously this relates to a period before Brown Rudnick came on the record. Brown Rudnick came on the record for the purposes of the appeal. Wasn't a party or wasn't involved in the security for costs appeal, but obviously involved in the current appeal. My instructions are that there wasn't an agreement as to the amount. But in any event, if it's the case that these costs haven't been paid, then one would assume that the respondent would obtain a cost assessment, get an order for payment, and seek enforcement of that order.
Well, you're saying they're not entitled or not allowed to take it as just a concern in regard of your financial abilities or difficulties.
I apologise, Your Honour. I didn't understand the question.
I'm saying raising such point in their letter of the 1st of June.
Yes.
In regard of the cost of that application, the $2,500.
Yes.
My question is, why they're not allowed to take it as a concern in regard of your ability to do it?
Because they're not allowed to take it as a concern because we've paid it. It's been paid. It can't be concerning to them. It can't be concerning to them that the amount's been paid, the 2,500.
Yeah, but the letter was written on 1st of June. When did you pay it?
Now, shortly thereafter. Yeah, maybe it'll be a missile making help.
Okay, so if it's after that, then nothing wrong with this statement, isn't it?
As of the first. Yeah, sorry.
Not even that. The point that's being made is not in relation to the 2,500, the indemnity costs, but there was a security for costs appeal before Deputy Chief Justice Chadwick, and costs of that appeal were awarded to the claimant. And if you refer to paragraph 51 of our skeleton argument, that sets out the sort of these costs from FDPL were initially sought on the 24th of November at a sum of 82,152, and then they were sought from FDPL's new representatives on the 18th of May 2016.
Well, it's all very well to seek them, but there's difference. If there's no agreement as to the amount, or there's no confirmation as to the amount to be paid, it's a different matter. The The appellant can't be expected to pay an amount that he hasn't agreed to pay. In the absence of an order, it's very difficult to see what the respondent can properly complain about. So that's the position as regards the respondent's submissions on this alleged prejudice it will suffer in the event that a stay is granted today. The next question, and it might be helpful, Your Honour, if I could just take you to another authority. And again, it's in the authorities that I have attached to the skeleton argument. And it's DNB Bank, October, decision of the Court of First Instance, Your Honour's decision of the Court of First Instance, 5th of October 2015.
Right, behind that court.
Yes.
Yes.
And it is paragraph 13.
Right.
And particularly the quote underneath. Now, over the page, where the quote continues, there is a section, certainly in my print off, that's underlined. Does Your Honour have that underlined section?
Yes.
Yeah, so those are the sorts of questions that I'm trying to answer. Those three questions, which are taken from a case Hammond-Suddards, the judgment of Lord Justice Clark. Those are the questions that I'm trying to address, and I'd like now to address the last of those questions. On the other hand, if a stay is refused and the appeal succeeds and the judgment is enforced in the meantime, what are the risks of the appellant being able to recover any monies paid from the respondent? Now, as the Honour will have seen from my skeleton argument, in my submission there are real risks that the appellant may suffer if the judgment is enforced. In the meantime, the appeal is allowed and the appellant then goes about trying to recover the money that it has handed over or has been taken from it by way of enforcement. The first of those risks is in the can be found in the judgment itself. Yeah, it's paragraph 206 of tab 10. Page 162.
Paragraph number again?
206.
Yes, right. I'm in there.
So paragraph 206 reads, Mr. Adil did not deny that PDEL was entitled to 25.5% of the shares in Frontera. Half of the 51% he held was clear from the shareholders agreement he signed. The question is then one of transfer of shares to PDEL. Now, taking you on to a judgment, taking you on to this judgment, and asking you to look at the detail of it isn't easy in the context of an application like this. I fully appreciate that. But, and Ms. Ahmed will tell me if I've misstated the position. But the respondent is admitting that a Mauritian company, which is controlled by the chairman of FDPL, Mr. Chaturvedi, was entitled to 25.5% of the shares in a company that they both were involved in. That was one of the allegations that was raised at the trial. And paragraph 206 records that Mr. Adil accepted that PDEL, Mr. Chaturvedi's, one of the other companies of Mr. Chaturvedi, was entitled to this shareholding in Frontera. Now, the question, one of the issues that arose at the trial was whether or not Mr. Chattavidi, whether Frontline, whether the PDEL was required to go to Mozambique to obtain the share transfer. So one would think, in circumstances where Mr. Adil has admitted that one of Mr. Chattavidi's other companies is entitled to these shares, that he would not contest or put up any fight in respect of any proceedings related to that shareholding. And yet, if I could take you on to tab 4 of the bundle, of the hearing bundle.
Excuse me, I just wanted to understand, what you referring exactly
Yes.
to this? We're talking about the risk the appellant might suffer, isn't it?
That's right. Let me make the point. Let me make the point briefly, Your Honour.
But sorry,
The point is
what
this.
I'm thinking, this is a statement that should comfort the claimant or the respondent that there is available assets for him, at least by that size, isn't it?
It's not relevant to it's not relevant to the issue of enforcement. It's relevant to the it's not owned by Frontline, those shares. It's owned by a related company. So those aren't assets against which the respondent can enforce any judgment against.
Right.
What I'm trying to use it to show is that is the attitude of the respondent to the appeal when it comes to claims which it has admitted, but in circumstances which demonstrate that, notwithstanding that admission, it is not willing to hand the shares over.
I see. Go ahead.
The point that I'm trying to the point that I'm trying to make is answering that question from Your Honour's judgment. If a stay is refused and the appeal succeeds and the judgment is enforced in the meantime, what are the risks of the appellant being able to recover any monies paid from the respondent? Well, the risks that the appellant may suffer, in my submission, are evidenced by the respondent's attitude to PDEL's claim for these shares, which in these proceedings, Mr. Adil admitted Mr. Chattavidi's company was entitled to. So, that's the basic point. If it's going to be very difficult, in my submission, for the appellant to recover monies that is paid over pursuant to an order in the absence of a stay, because this is a respondent, this is a party, that even where it admits that its opponent is entitled to shares, notwithstanding that, it continues to fight in the courts and say that it's not so entitled to those shares. And the evidence that shows Mr. Adil's position is at tab 4 of the bundle, of the hearing bundle. And it's page 39.
Right.
So this is a judgment of the Judicial Court of the Maputo Province in Mozambique. PDEL is Project Development and Engineering Limited, and this is an application, this is a judgment in respect of PDEL's application for an injunction. You will see the parties there, PDEL, Frontera and Mr. Adil and others. And if you could turn over the page to page 40, this is PDEL's request. It's the third bullet point down, and the third bullet point reads: the summons to the defendants Asif, Adil and those other two to proceed with the division and transfer in 25.5% of the shares of Frontera. Precisely the amount that Mr. Adil says has admitted in these proceedings at trial that PDEL is entitled to. Now, one wonders. I'm not going to, hide behind the fact that this is a judgment in respect of an injunction that PDEL has sought for the division and transfer of those shares. The Mozambique proceedings, and there are a whole series of Mozambique proceedings involving PDEL and Mr. Adil, are ongoing. And I haven't got all the documents to show you, but nonetheless, this judgment, in my submission, demonstrates that, at the very least, it demonstrates Mr. Adil's attitude to a claim for these shares, which is, I'm going to fight on what PDEL isn't entitled to.
Where is the contradiction now, exactly? So, is it that because he claimed the shares, or...
The contradiction exists because if this was truly an admitted claim, if Mr. Adil truly accepted that PDEL was entitled to that shareholding, there would be no need for any proceedings for the recovery of those shares whatsoever. Mr. Adil will just hand them over. But he hasn't. He's involved in these proceedings in Mozambique, and that, in my submission, is relevant to the question of whether or not he will hand over monies which he has obtained in circumstances where a stay is refused. If I could take you to what the respondent says about this, and it's back to the respondent's skeleton argument. Sorry, I need to get the reference on the iPad, but it is the respondent's skeleton argument. 36 in here. Yeah, it's paragraph 36, Your Honour.
Right.
So just before that, in fact, the sub-paragraph above paragraph 34 is no evidence for a respondent's inability to repay if FDP are successful in appeal. One of the grounds for ordering a stay can include that there's a risk that the party applied for the stay may be unable to recover. FDP has not provided any evidence of the respondent's inability to repay. No reason for the applicant to suspect that the respondent will be unable to pay. And here it is, 36. The respondent submits that the existence of a dispute does not warrant the conclusion that the respondent is or would be willing or unable to repay the money if it were now paid, and FDPL is ultimately successful in the appeal. And for that proposition, the respondent cites the Karafi case. Now, the difficulty with the respondent's position is that the dispute, so the relative merits of the dispute that the Karafi case and Justice Giles is referring to there is about the appeal, right? So, what Justice Giles in Karafi is saying is the fact that the parties are in dispute as to the merits of the appeal, one party saying that it has a good case on appeal, and another party saying that it hasn't, is irrelevant really to the question of whether or not to grant a stay. Yeah? Well, this paragraph is saying, well, the existence of a dispute in Mozambique is irrelevant to the question of whether or not it's willing to repay the money. Now, in my position, that can't be right. That can't be right. The position as regards the share transfer and is admitted by Mr. Adil. It's admitted. There is no support for the proposition that Mr. Adil will pay over the money when, if the appeal succeeds in its order to do so. And the existence of a dispute in Mozambique very clearly suggests that Mr. Adil will be very difficult in the event he's required to hand that money over, and that is a relevant consideration for Your Honour in determining what prejudice the appellant will suffer in the event that the stay is refused and the appeal is allowed.
Well, tell me, the proceeding in Mozambique is like more than 2 years, I guess, and there must be a determination in that regard. So,
There is no determination, Your Honour. Unfortunately, these proceedings go on and on. So the latest update from Mozambique is as at the 31st of March 2006. The civil suit, so the substantive proceedings, have been issued, and it's yet to be listed. So there will be a trial, it seems, in Mozambique as to the recovery of shares by PDEL, which Mr. Adil has admitted PDEL is entitled to. If that's his attitude in respect of an admitted claim, then one can only wonder what his attitude will be if the judgment is enforced, he gets his money, he loses the appeal, and is required to hand the money back.
would you please tell me how much that share is worth? 25%. Do you have an idea? Or then we leave that.
I don't know that I can assist. I don't know that I can assist on the budget. Yeah. You get my, you take my point on it. It's the attitude of Mr. Adil and the circumstances that I'm, relying on.
Yeah, I see your point. Yes.
Importantly, it's worth recalling as well that the Mozambique judgment and the reference to Mr. Adil's attitude in respect of the share transfer was contained, as you saw, in an exhibit to Mr. Sequeira's witness statement in support of the application. So when we filed the application, we exhibited the Mozambique judgment to Mr. Sequeira's witness statement. Mr. Adil, in his response, filed on Sunday, said nothing about the position in Mozambique. There's actually nothing. It says, doesn't say, no, this is all wrong. The position in Mozambique is much more complicated. The fact that I've admitted that the shares are entitled to PGL is irrelevant. No explanation at all. This doesn't feature in the witness statement and response. He's got no answer to it in my submission. Again, more evidence in my submission that the appellant will suffer difficulty if he has to recover money handed over following a successful appeal.
And why we cannot take it this way? So the shares is for your client until or unless the claimant managed to transfer that to his, until he wins that application in Mozambique. Well, so the fact would remain the same until the court decide otherwise, isn't it?
There might be a couple of difficulties in that. The first is that the parties are different. So, the shares, the shares are Frontline's, my client. The shares are PDEL's, a company which Mr. Chatterjee is controlled with. And the other issue I see with that potentially is that you're dealing with two sets of proceedings in different jurisdictions. And so there's a question about whether or not you can, and other than by agreement, whether you can link the two sets of proceedings in respect to the share transfer, and from Mr. Adil's attitude in respect of the Mozambique proceedings, it's very difficult to see that the parties would ever agree that the position would remain the same pending the determination of the appeal. But no, I can see some sense in it, but I wonder whether practically.
I'm very clear with that. My question was just to add any value to your argument that the credibility or even the attitude of the claimant.
No, that's right. So I've got two more short arguments, and then I'll hand it over to Miss Ahmed. Both of these arguments relate to the ability of the appellant to recover money handed over following a successful appeal. So, and one of them relates to, the first one relates to the security for costs appeal in these proceedings, which is at tab 9 of the judgment. Of the hearing bundle, I apologise. Tab 9. And again, Your Honour, it's one of your decisions. So, if I could take Your Honour to Paragraph 6. So you want to recall, this is the defendant's application for security for costs. It was finally determined after the trial in this case. The Court of Appeal document came out after the trial. But nonetheless, the Court of Appeal issued a judgment. And if I can take you on to paragraph 6, the last sentence of Justice Chadwick's judgment, the last sentence on that page 101 said there was no dispute that the claimant had transferred the property which he owned, a flat into buy to his wife in or about March 2013. There was no, over the page 102, no suggestion that he took the step with the intention of defeating the claims of the creditors. The intention was not a relevant factor for the purposes of the IDC and deciding whether or not to grant security. Paragraph 14 over the page, middle of page 103, the court accepts that condition 6 in IDC 25 was satisfied in that the claimant did transfer the property in March 2013, which had the effect of making it more difficult to enforce an order for security for costs against him. Right. So that's undisputed. Court finds he's made it more difficult to enforce a cost order against him. But the court goes on to paragraph 15 and deals, you may recall, Your Honour, with the claimant wife's undertaking to pay, and the undertaking is set out in paragraph 15. The offer was to provide an undertaking, there's a second sentence, the offer was provided an undertaking by the claimant's wife to pay on first written demand such costs as might be ordered by the court or agreed in the amount of up to $200,000. Paragraph 16 is the answer. Disposing of the appeal in the circumstances had the matter calm before court, no reason to doubt the court would have taken a view, not just to make the order for security. The defendant had a readily enforceable undertaking which would enable it to recover $200,000 towards costs. Over the page, and the appeal goes up, the reasons go on. But the point is, the Court of Appeal finds that he's transferred assets out of his name into his wife's name, but no security for costs because of the wife's undertaking to pay costs up to $200,000. So we raise this issue and say we're concerned about respondents' ability to pay in the event the appeal is allowed. And Mr. Adil puts in his witness statement. If we can go to his witness statement at tab 18. Paragraph 13, page 222 of his witness statement.
Yes.
It's paragraph 13 reads, as regards the risk of non-recovery or FDPL facing difficulty in recovering the penalty in the event that it's successful, I say the following. 13.1. I have previously offered the defendant an undertaking in response to the security for costs application. The undertaking, which was to be given by my wife, was secured against the property in Dubai owned by my wife. At the time, the defendant did not accept the offer. However, and this is the sentence I really focus on. However, if the defendant is legitimately concerned about my ability to pay the penalty in the event it is successful in the appeal, the defendant could have approached me and sought an undertaking on a similar basis. It did not do so. The first thing that was surprising for me when I read that sentence is that he doesn't actually offer the undertaking. Right? So this could have been this whole point could have been short-circuited by the defendant's wife. The wife providing the undertaking that he get of some form in respect of costs, in respect of handing over the money in the event the appeal is allowed, the 1.6 million in costs. But that hasn't happened. All his complaint is, the defendant didn't approach me for such an undertaking. So the position as regards the respondent's assets in Dubai is very unclear. We know, and the Court of Appeal has found, that he has moved property out of his name, and that makes it more difficult to enforce a cost order against. That's a finding of the Court of Appeal. We know that it wasn't satisfied wasn't happy to award security at trial because of the undertaking, but we don't know what the position is as regards the wife's undertaking now. And it's surprising in my submission that the defendant, the respondent, hasn't offered a similar undertaking in respect of the appeal and the enforcement. Now, in the event that such an undertaking on the same terms is granted, in the event that Miss Ahmed stands up and says, I have instructions to offer an undertaking on the same terms as at trial, here they are, I'll do it, I'll deal with your concern that my client won't be able to pay in the event that the appeal is allowed. In the event that happens, I would say this: the amount, as Your Honour will have seen from the judgment of the Court of Appeal, is up to $200,000. Right? Now, as Your Honour is aware, the amount, the penalty, is 1.6 million plus costs. So even if Miss Ahmed, I don't know what Miss Ahmed's position is, but even if she does stand up and say, well, I've got an undertaking on the same terms, in my submission it doesn't go nearly far enough to give comfort to the court that he won't be good for the money if the appeal is allowed. And in those circumstances, in my submission, the defendant is rightly concerned that he won't be able to recover in the event the stay is not granted today and the appeal is ultimately allowed. I made one very final brief point about the residency of the respondent, and again, I accept fully that this is a supplementary point, but nonetheless, it's important in my submission to make it. We can go back to the judgment of the Court of Appeal in the security application, so that's tab 9. You see, just like way of background, in our application and in Mr. Sakara's witness statement, what we said was Mr. Adil's residence is uncertain. We're not sure where he resides, and there is some evidence that he certainly for some parts of the year, or perhaps the whole year, resides in Mozambique. Though that would make it more difficult for us to recover money in the event that it's paid over and the appeal is allowed, and so the court should be concerned about that. The answer that we get from the respondent is, well, he has a residency visa permitting residence in the UAE. And if you turn to paragraph 7 of Justice Chadwick's judgment,
yes,
what you will see there, about halfway down, is the fact that the claimant holds a residency visa permitting residence in the UAE is of little materiality in determining whether that condition is satisfied. The claimant, this is the sentence, the claimant may hold a residency visa permitting residence in the UAE but choose to reside elsewhere. So the fact that he's got a residency visa in my submission isn't determinative of the question of his residence. If I could take you to tab 4 again, Mr. Sakara's, the exhibit to Mr. Sakara's witness statement in support of the application.
What page is that?
Page 40.
Yes.
And about 1, 2, 3, 4. The 5th bullet point down, it starts, the defendant Asif Adil.
Yes, I see that.
The defendant Asif Adil is a businessman and business manager that develops business in several business fields, and he's currently in Mozambique. again, support in my submission that if the appellant is required to enforce a judgment, it may find life difficult if Mr. Adil is in Mozambique. That's, again, and in any event, there isn't any evidence in either Mr. Adil's witness statement or elsewhere in the papers that he has assets in Dubai against which the appellant could enforce in the event that it had to. The fact that his residency is uncertain, I put it no higher than that, and the evidence on residency points towards Mozambique. And for the other reasons I said, the position on the undertaking and the position on the shares, in my submission, when the court comes to consider that question at paragraph 13 of your judgment, Your Honour's judgment in DNB Bank, the court should be rightly concerned about the position of the appellant in the event that a stay is refused, but the appeal is ultimately allowed. Now, a final point on the merits. I sense that if a lawyer in a DIT course making an application for a stay mentions the words merits of the appeal, then in the sort of inevitable response of the court is that it's just completely irrelevant to the question of whether or not the stay should be granted. And I don't, as I said at the start of my submissions, I don't substantially dispute that position. But it is in my submission of some importance when there is some uncertainty as to where the balance of prejudice lies, which is ultimately the test that the court has to apply when deciding whether or not to grant a stay. And if I can take Your Honour to Leicester Circuits, and that is in the hearing bundle, again at tab 4. And it's page 16 of the bundle.
Yes.
Leicester Circuits is an important case only because both parties rely on the judgment of Justice Giles in Karafi. Justice Giles refers specifically to Leicester Circuits and says this is a case which summarises the relevant principles. Paragraph 13 of the judgment at page 16. The proper approach is to make the order which better calls within the interest of justice. Where there is risk of harm to one party or other, whichever order is made, the court has to balance the alternatives to decide which is less likely to cause injustice. Normal rule is for no stay, but here's my sentence. Where the justice of that approach is in doubt, the answer may well depend on the perceived strength of the appeal. So there may be some role for the merits, and there is authority both in this court and as approved by Justice Giles in Karafi in the DIC court for some reference to the merits. And the final authority in my bundle of authorities is the decision of last week of the Court of Appeal in the Tallinn National Bonds and DR Development case, again, which Your Honour was on the panel of, as to the payment of enforcement fees on the issuance of an enforcement application. You will recall in that case, Justice Omar Amaheri ordered that DR pay 3% of the judgment sum on the making of an application for enforcement. The Court of Appeal allowed DR's appeal in that case and said that it could construe the relevant practice direction which ordered 3% of the judgment sum to be paid in a purposive way. In effect, to avoid injustice to DR in the circumstances where there was no final enforcement order made. So DR hadn't had an opportunity to make submissions in respect of the interim order that was made, and the Chief Justice and the Court of Appeal said that's not fair. We can interpret the practice direction purposively to avoid that injustice, and the appeal is allowed. Well, in my submission, that is of some relevance to our situation, to our case, as regards the interpretation of Article 18. because it suggests that. Article 18.2, maybe, not foreshadowing what might be argued on appeal, but maybe interpreted purposefully in a similar way to avoid injustice. To the extent that the justice of no stay is in doubt,